Okay. So it is 9:30, so let's get started. So welcome everyone. Thank you for taking the time to attend this workshop. We're very happy to be here with everyone today. My name is Julianne, and I'm here today with my colleague Gail, who will be presenting with me. We are both lawyers and plain language specialists working at Éducaloi. For those of you who may be slightly less familiar with Éducaloi, I'm going to quickly explain what we do. So Éducaloi is a nonprofit organization started in the year 2000. It's not a government organization, despite our official color being blue as well. So a lot of people often think that we are government affiliated, but we are not. We are a nonprofit that is completely neutral, separated from the government. And Éducaloi's goal is really to make the law more accessible for people in Quebec by giving them reliable legal information in clear, everyday language that everyone can understand. Éducaloi is best known for its website, which you do see on the screen right now, éducaloi.qc.ca. It has over 1,700 articles, videos, guides, pamphlets, and more in English and in French, everything for free. Sorry, on different topics like criminal law, housing law, labor laws, etc. So any question regarding, bullying, is this legal? Is this not legal? Generally, it's a great place to go for some basic information. Éducaloi also has a second website specifically for legal education, which you see on the bottom of the screen there. So legallifeskills.ca or éducationjuridique.ca. It's the same website, just in French or in English. And that one really offers, free, ready-to-use content tools for educators like yourselves, including complete teaching kits with PowerPoint, with notes, teaching guides, a student workbook as well. We also offer volunteer-led workshops and other content adapted to schools in Quebec that you can just download for free, request for free, and access for free as well. So that's a great place to look for tools to teach the CCQ course. Or just to, teach other courses as well, if ever you want to just include a little legal aspect to your content.
Now, just a few guidelines before we get started. Please raise your virtual hand if you want to intervene, and please keep your mic muted when you're not speaking. Also, if you prefer writing your questions instead, feel free to do that. We'll be keeping an eye on the chat so you can write your questions there. And we'll also be asking you questions during the workshop. So feel free to participate, share your thoughts and opinions, if you're comfortable doing so, of course. Today, we're really going to be sharing with everyone here today legal information. That is to say, general information about the law. So we'll explain what the law says, what options are available to you, but we won't be giving out legal advice. So if there's anything specific to your own situation that would require an interpretation of the law, or telling you what you should be doing, then we might not be able to answer your question. However, we will be sharing resources at the end so you can use them to get more help. And our website that Julianne showed before would be one of those resources. And just something to keep in mind today, the information that we're giving is really going to be based on Quebec law. So the rules could be different in other places.
Absolutely. So on that note, let's get started with a couple icebreaker questions just to get to know each other. You can answer by, again, raising your virtual hand, and then we'll ask you to unmute yourself, or by writing in the chat if that's what you prefer. So our first question for everyone, how old are your students? A, 5 to 10 years old, B, 10 to 15 years old, C, 15 to 20 years old, or D, 20 and older. We've got lots of A's, B's. Now we have a couple C's as well. Yeah, B. Someone said B. A and B. I think we've got mainly 5 to 15-year-olds and a couple 15 to 20-year-olds, but I haven't seen any D's go by. So it doesn't seem like anyone is teaching 20-year-olds or older, so adult education. Great. So yeah, it seems like today's workshop on, again, the CCQ course aspects, the legal aspects in the CCQ course is going to be really interesting for everyone because we are going to be covering elementary and high school grades. So that 5 to 15-year-old range is exactly what we're going for today. Here's a second question for you all. Which of the images on the screen best represents your comfort level when it comes to talking about the legal framework about around young people's romantic and sexual lives? So how comfortable are you discussing the legal side of these topics with your students? You can, again, answer in the chat. And since images can be interpreted in different ways, feel free to explain why you chose your image if you're comfortable doing so. If I give maybe an example, someone could choose, B because, it's like being in the middle of a storm with questions coming in left and right, but you're steady like a lighthouse, not scared to answer questions that your students have and guide your students on the right track to finding answers. We've got A and B's again. B, because it doesn't make me feel uncomfortable. Well, I'm just gonna mute someone here. It doesn't make me feel uncomfortable, but I feel pretty confident guiding them. B, yeah. C, the conversation flows and it's usually very engaging and we enjoy the conversation. D as well. I think we've got a bit of everything here. So thank you for those of you who shared. It's completely normal to feel, more or less comfortable talking about romantic and sexual relationships with your students. These topics are very personal and they also involve, again, legal rules that can sometimes be very complex. Today's goal is not to make you all legal experts, but to give you some clear reference points and practical guidance so that you can feel more confident when dealing with these topics and talking to your students.
Just as some sort of fun fact, I guess, this workshop was specifically created for this training day. Can you hear me? Okay. For this training day. So we're really excited to share this new content with you all today. And the workshop was really designed to help school staff, such as teachers, sexologists, to help them better guide or support discussions with young peoples about their romantic and sexual lives. So we'll be discussing topics that can be sensitive, but they're very important and very common in school settings. So there might be situations that we'll talk about today that you've already seen or that you'll encounter at some point. So that's why today we're really going to approach all those topics from a really legal perspective and not a moral perspective. As Julianne mentioned, the goal today is not to make you experts, but really just to help you understand where the legal boundaries are, to help you distinguish between what's legal, what's illegal, what's criminal in young people's romantic and sexual lives. And we'll go over the differences between all three a bit later. Also, to help you understand under what conditions or circumstances sexual consent is legally valid, also to help you identify risky or illegal situations that may come up in young people's lives. And finally, last but not least, to help you apply your legal obligations and direct students to the appropriate resources. So the workshop today should last about an hour and a half, but we'll be taking a break in the middle. And the workshop will be divided into 5 sections. So we'll do a quick introduction before looking at consent by children and teenagers, what the law says, what conditions are required for consent to be valid, and in what situations consent is not legally valid. We'll also be looking at risky and illegal situations. So it's just some crimes to be aware of that are related to young people's romantic and sexual lives. And then we'll also be looking at the responsibilities of school staff. So what the law requires of you as members of a school community. And finally, we'll quickly conclude and share with you some resources that are available not only for you, but also for your students. So let's wrap up this introduction with a quick final icebreaker question. And also we'll do an overview of how today's workshop connects with the culture and citizenship in Quebec program that Julianne quickly mentioned before. So question for everyone, you can raise your hand or answer in the chat. Do you ever talk about aspects of young people's romantic and sexual lives in your work? And if so, which aspects exactly? So if everyone wants to share, you can write in the chat, or you can, again, raise your hand. Just open the chat here. Sometimes it
Yes, sometimes
depends.
it depends. You can also write, just examples of types of things you might cover.
Yes.
Are there any terms that come up in your mind that may or may not be legal that you discuss with your students?
As I teach grade two. Yeah. So some examples that might come to mind, maybe to give you some inspiration. So maybe consent is a word that might come up. Sexual education, and answer every and all questions that arise. We also discuss frequently consent, yes. Navigating friendships, yes, and boundaries, very important. Thank you for sharing. Consent, every year of high school, consent, boundaries, romantic and relationship aspects. And in science, we speak about anatomy, the act of sex, and safe sex. Yes,
Someone also shared, we talk about what age they can date, which is a big one as well that we'll be
that's
discussing
true.
today.
Consent, boundaries, healthy relationship, boyfriend, girlfriend. Yes. Well, thank you all for sharing. All those aspects do have a legal dimension and are related to young people's romantic and sexual lives. So, all this to say that you're already dealing with more legal aspects that you might think. And so, this workshop will probably be very interesting for you all today, which is why you're here. Um, the legal framework about around young people's romantic and sexual lives often involve difficult situations. So there may be cases of abuse or distress among your students. And in these situations, you might find that some of the tools that we're going to be sharing at the end are going to be useful both for you and your students. Something to know is that the law offers protection. So once you know what the law says, you can more easily avoid difficult situations. You can more easily prevent harm and find some solutions and information. So it's really helpful to have some basic legal knowledge to know what to do when a situations like this arise.
So before we dive into the legal content, it's important to understand that this workshop was created while really keeping schools and the curriculum in mind. So today's workshop is actually closely aligned with the Culture and Citizenship in Quebec program. And how so? Well, the topics covered in this workshop relate directly to situations young people, your students, may experience in everyday life, like relationships, consent, personal boundaries, online interactions, identity, relationship with others. So these are all things that you mentioned for that last icebreaker question, things that came up. So as you see, it's very, very much relevant to their everyday lives. One of the main links to the CCQ program is through the competencies students are asked to develop in the course. So for example, at the high school level, the program encourages students to study cultural realities and reflect on ethical questions. And that's exactly what many of the topics in this workshop invite students to do. So, to think about their actions, their relationship with others, and the consequences as well of those actions. For example, students may be asked to reflect on how to recognize consent, which is a big one, how to respond to a situation involving violence, where to get help, what to do, how to respect other people's boundaries and rights, or how to better understand realities related to, gender identity, sexual orientation. Another important point is that sexuality education is already integrated into several CCQ themes at the elementary and secondary level. In fact, sexuality education content is covered in some way at every grade level, and the topics of sexuality education are connected to the same themes and competencies that we just saw. So the topics discussed in this workshop on the legal framework of your students' romantic and sexual lives aren't coming out of nowhere. They're really topics that your students will already be somewhat familiar with through their other classes. Concretely, in this workshop, we'll discuss topics like related to young people's emotional, relational, and sexual lives, including the conditions for valid consent, such as age, age differences, or certain prohibited power imbalances in relationships. We'll also look, again, as Gail mentioned, certain crimes related to relationships and sexuality, like sexual assault, criminal harassment, or stalking, sharing intimate images, or luring as well when an adult talks to a minor, trying to get them to do some sexual activities of some kind, violence in relationships as well. And again, legal obligations of school staff, like reporting situations to youth protection services or applying the anti-bullying measures in a anti-bullying, anti-violence plan that the school might have already implemented. And then also protections against discrimination based on sexual orientation or gender identity. The goal again here is not to scare students or turn relationships into legal issues. The main objective is to encourage understanding, prevention, and the development of respectful and safe behaviors. Finally, it's important to remind everyone that today's workshop focuses on the legal perspective of things. The information we'll present today applies specifically in Quebec. So some concepts like the age of sexual consent or criminal harassment comes from Canada's criminal code, so that does apply the same across the country. But other rules discussed are specific to Quebec and may not apply elsewhere in other provinces, territories in Canada. It's also important to remember that teachers and other school staff are not judges, police officers. Your role is to educate, prevent harm, and support students. So again, the purpose of this workshop is not to turn anyone into a legal expert, but to give you part of the tools you'll need to fulfill your role.
Great. So now we're going to move into the first topic of the workshop. So consent by children and teenagers, more specifically, sexual consent. So what exactly do we mean by sexual? Um, a sexual act can include any gesture or behavior connected to sexuality or to intimate body parts. So, for example, a kiss, touching or caressing someone else, touching intimate body parts, sexual activity, or even something without any physical contact, like sending a sexual message or sharing a sexual photo. So, sexual doesn't necessarily only refer to intercourse or sex. It can include a lot of different kinds of behavior. There's another thing that's important to clarify. It's that romantic relationships between two kids or between two teens are not illegal in and of themselves. So the rules about sexual consent don't apply to non-sexual romantic relationship. So here we talk about things like the fact of being in a relationship, just holding hands, spending time together, maybe just flirting. So those would be considered non-sexual romantic relationships. And the government of Canada even recognizes on its website that those types of romantic relationships are a normal part of young people's development. That being said, until a person turns 18, their parents and to some extent even schools can still have a responsibility when it comes to their supervision, their education, and their safety. And because of that, they can set rules like curfews, limits on outings, and any other rules that are meant to support safety and well-being. Now, in the following slides, we're going to look at, can I have the previous slide, please? Yes, thank you. On the conditions of valid consent, the limits of consent, the age and age gaps, and the nature of the relationship between the people involved. Thank you. And before we look at all of that, another quick question for everyone. If someone says nothing and stays passive, it means that they consent. True or false? So you can again raise your virtual hand or write in the chat. So I see a lot of false, not consent, a lot of false, false, false. So we seem to have a consensus here in the chat.
Yeah, it seems pretty clear here. Everyone's answering false, and that is the right answer. It is false. So let's look at what consent actually is. There you go. So when it comes to sexual activity, so sexual consent, we're really talking about voluntary agreement to participate in a sexual activity without pressure or coercion. So again, here a maybe is not a yes. Under the law, consent really has to be clear and what we call enthusiastic. So again, clear and you have to be able to really see it. This means that consent can't be assumed. It really has to be expressed through words, actions, or behavior. Again, and that behavior has to be clear. Next, each person involved must give their own consent. So no one can consent on behalf of someone else. Consent must also be given at the time of the activity. So it can't be given in advance. It's not given either because you're in a relationship, because you're married. So it really has to be given at the time of the activity and it can be withdrawn at any time, even if the activity has already started. So for example, you might consent to a kiss, but you might not consent to things going further. So even if it's around the same time, it's possible to say, well, I was okay with that, but right now I'd like to take things slower and stop here. So we can withdraw consent at any time. And finally, the law also requires that each person take reasonable steps to make sure their partner is consenting throughout the activity. And what do we mean by reasonable steps? So this can include simply, asking the person, is this okay? Can I do this? Are you okay with doing that? But it's also just, paying attention to the partner's reactions. So for example, if someone becomes silent, freezes up, or seems uncomfortable, these are signals that should prompt a check-in about consent. So a couple examples of behaviors that could indicate a lack of respect for consent include, pressure, persistence, guilt tripping, ignoring a no, whether it's a verbal no or even a nonverbal no. If, someone pushes back, if they start crying, these are all signs that, consent may not be respected. If there's anger or manipulation involved after a refusal, that could also be a lack of consent. Assuming consent also without checking. So all of these are things to be aware of, that it is a time to, have that check-in about consent and make sure everyone agrees with going forward with the activity. Next, it is very important to know that consent is not valid if a person is asleep or unconscious, obviously, or if they are too intoxicated to understand what's happening. So when it comes to alcohol and drugs, it really depends on the situation. It varies based on the level of intoxication. So courts always look at the person's actual capacity to understand and make decisions at the time of the event. So it's not because someone just took some alcohol that for sure their consent is not valid. It really depends on the level of intoxication. And so depending on the person, the amount of alcohol, the amount of drugs that they take might be different for when consent is valid or not. Consent is also not valid if the person is under abuse of power or trust. And we'll come back to this later. We mentioned that, for a relationship, a sexual relationship to be valid, there could be age gaps, but there could also be, these imbalances of power that we have to make sure are not there. Consent is also not valid if the person is deceived in a way that creates a serious risk to their health. An example here that was recognized by the court is if a person living with HIV doesn't disclose it to their partner when there is a real risk of transmission. As of now, the courts haven't looked at other STDs, but the court mentioned that this type of reasoning could also apply to other STDs depending on the circumstances. So if there's a real risk, a serious risk to the person's health, and they weren't, made aware of that risk before activity took place. So these are the rules regarding sexual consent that apply to everyone, no matter their age. But when we're talking about, children, teens, minors, there are additional rules to follow. So sexual consent for young people also depends on age and the age difference between the two people involved. First, for a child under 12 years old, consent is never valid. So this means that if the partner is 12 years old or older, pardon me, Any sexual activity they have with the child, so the person that's under 12, is technically sexual assault under the law. If the sexual activity takes place between two children that are both under 12, both children are actually too young for criminal liability, meaning that neither can be accused or found responsible of a crime. In this case, where it's, activity between two children under 12, both children are considered victims under the law. And so if there's any implication by the police or other services, they will treat them as victims and be there more to help, support, rather than punish the people involved. Now, when someone is 12 or 13, so once the child reaches 12 years old, or if they're 13 years old, the other person that they're with, that they're consenting to sexual activity with, must be less than 2 years their senior. So this is up to 2 years minus 1 day older than them. Once someone is 14 or 15, the other person must be less than 5 years older than them. So again, here, up to 5 years minus 1 day older than them. And then from age 16 onwards, there are no more age gap restrictions. So technically, a 16-year-old could go out with a 25-year-old if there are no other situations, the power imbalance that we were talking about that are in place. But there are no more age gap restrictions. While someone is still under 18, their parents, again, as Gail mentioned, do still have the responsibility to protect and guide their children. So again, this means that parents can intervene or limit certain relationships if it's in their child's best interest and safety. And we'll see later that failing to respect these age differences can be very serious and maybe even criminal, depending on the situation, depending on the ages. And that's something we'll come back to.
So now we're going to look at a quick situation related to everything we've seen previously. I'll just read the scenario out loud and you can think about your answer. Maya is 14 years old, so she's in secondary 3, and Samir is 17 years old, so in secondary 5. They're both in a relationship together. You hear some staff members say that this relationship is unacceptable and that Maya is way too young to date Samir. Is the age gap for valid sexual consent respected? So you can answer in the chat with your answer. If you think yes, you can also add your reasoning. Same thing if you think no. So it's respected. Yes. Do you remember what the age gaps are for those years? For those ages, 5 years. Yes, so everyone got it correct. The age gap is indeed respected because Maya is 14 years old, so they're allowed to consent to sexual activity with anyone who is less than 5 years older than them. And in this case, Samir is only 17, so only 3 years older than Maya. So in this case, this is correct. Now, another question for you all. Are there any situations where even if the age gap is respected, there would not be valid sexual consent?
Can you maybe give an example of these types of situations that would um, be not valid consent? Have you ever seen any of these situations in your work? You can maybe write in the chat if you think, what could make a teen's consent not valid, even if age gap is respected.
So Joanne, for example, mentioned one before with the power balance. Yes, power imbalance, position of power, alcohol involved. If one student is tutoring the other, so there's a sort of relation of authority. If Samir is Maya's boss, yes, so again, some sort of power imbalance. Yes. So Indeed, even if the age gap is respected, consent can still be invalid because of the nature of the relationship between two people. So, if a person is under 18, the consent would not be valid if the other person that they're dating is in a position of authority. So, someone mentioned if Samira is Maya's boss. So, if the other partner has some sort of power over the young person, then the consent of that young person would not be considered valid. Another situation is if the other person is in a position of trust. So when the older person leads the young person to believe that they're under their protection and they can be safe with them. So, for example, if the older person is their teacher, maybe their sports coach or their mentor, someone mentioned also a tutor. So all those could fall under the younger person being in a position of trust with the older person. And another situation would be, yeah, those situations, yeah, sorry. Yes, another situation if the other person is exploiting the minor. So when the older person is using the young person's vulnerability for their own benefit. There are many factors that can help a court decide if there's exploitation present or not. And those factors include the age of the young person, the age gap between the two people, the way that the relationship developed. So, did it happen really quickly? Did it happen secretly and no one really heard about it? Did it happen online? And another factor that the court will take into consideration is the level of control or influence that the other person has over the young person. So finally, the last situation in which the consent would not be valid is if there's a situation of dependency. So dependency includes a sense of inequality or imbalance in the relationship. So for example, if a young person is staying with the other person and has nowhere else to go, then this other person becomes some sort of a trusted figure that has significant influence over them and the choices that they can make. So all in all those situations are kind of similar in nature. The general idea is that the older person has some sort of power or influence or control over the minor.
So here's a quick recap on the screen on sexual consent when it comes to young people. So you really do want to ask yourself two or three questions depending on how you look at things. The first one is the age gap respected? If yes, then you move on to the next one. Is there valid consent? So again, to be valid, consent has to be voluntary, clear, and free from pressure. The person has to understand what they're consenting to, and they have the right to change their mind at any time. So there will not be valid consent if there's a problematic situation at hand. For example, if the person is intoxicated to a point where they no longer understand what they are consenting to, so the consent is no longer informed. Or, for example, if there's a power imbalance in the relationship where their, consent may not quite be as free from pressure or free from influence as it needs to be valid. So again, this is the case, for example, if one person is in a position of authority or trust with the younger person. So all this information, this recap screen is very important to share with your students because, for example, well, actually not for example, Quebec's Director of Criminal and Penal Prosecutions actually recently came out with an article stating that in many sexual assault cases involving teenagers, the issue often stems from a misunderstanding or a lack of understanding of consent. Some teens, downplay certain behaviors, lack the tools to understand and manage their sexual impulses. They believe they can keep pushing after being told no, or they misinterpret another person's silence, hesitation, or discomfort as consent just because, well, they're currently, exploring their sexuality, so they don't quite expect the need for that clear yes, and so they don't quite understand what consent is. So again, teens are still learning about relationships, emotions, intimacy. So this can sometimes lead to awkward or inappropriate advances. But it's really important to know that these behaviors are serious when they cross the boundaries of consent, and there can be very serious consequences as well, as we will see in the next section of our workshop. So before we move on to that next section, there is one more thing we want to cover. So consent still, but this time in the context of healthcare. So certain situations can come up in the context of young people's romantic and sexual lives. So for example, can a child or a teen make decisions on their own without their parents' consent? And so this really depends on the teen's age or the child's age, the type of care involved as well. What are we consenting to? And whether the situation is urgent. So is that care required to save their life, for example, or are they unconscious after an accident, etc. So these are the types of things we'll look at now. So here's a question to kick things off. So again, true or false? A 15-year-old student can have an abortion without her parents knowing. Would this be possible, or would the hospital, the medical staff involved have an obligation to let her parents know? So true or false, a 15-year-old student can have an abortion without her parents knowing. So we've got mixed answers here. We've got some trues and some falses. I think it's true, but it's a good question. Not sure. Yes, she can. We have someone who put false, but with a little question mark there. I don't know. And the answer is true. So a 15-year-old student can have an abortion without the parents being, notified, without the parents knowing. We'll see why as Gail explains the rules regarding consenting to healthcare.
Yes, thank you. So indeed, whether parental consent is required or not will really depend on the age of the minor. So before the age of 14, the parents have to authorize for their child, but they have to take into consideration their child's best interest and also their opinions. If there's a disagreement between what the parents want and what the child wants, then depending on the circumstances, we might have to ask a court to intervene. After the age of 14, a young person can consent to their own health care when it is necessary for their health. What do we mean by necessary care? Now, that would include contraception, medical consultations, visits to psychologists, and similar example. Abortion would also be considered necessary health care. So that's why in the example that we saw previously, um, the person could consent on their own without needing the parental consent. Now, just because a person is allowed to consent on their own doesn't mean that they can refuse. It also, sorry, being able to consent alone to necessary care also means that someone can refuse care on their own. If the parents want to override that refusal, now they have to go to court. So, for example, this means that a parent cannot force their 15-year-old to be vaccinated or to undergo medical tests or even to have an abortion. They'd have to go to the court to override the child decision. It also means that the parents of a teen that is older than 14 will not be necessarily informed about their child receiving necessary care. So it's really up to the child to decide whether or not they want to inform their parents. There is, however, one exception to this rule. If the minor is staying in a health or social services institution for more than 12 hours, now the institution would have to notify the parents. It's also important to note that these rules could be set aside in situations where it's an emergency and there's a danger to life. So, for example, if a 16-year-old is in a car accident, needs life-saving care, then in that situation, we might obtain the consent from the parents before providing the treatment. And there are also other exceptions related to mental health, and that would fall under what we call involuntary care, but we're not going to cover that topic today. Now, we've talked about necessary care, but there's also another portion of care, which would be optional care. So that's care that's not necessary for the person's health. Think about tattoos, piercings, cosmetic surgery. In those situations where the care is not necessary for the person's health, the parent's consent would still be required even if the minor is older than 14 years old. So we've reached our first question period. Were there any questions? You can write your question in the chat or again, raise your hand and we'll be happy to answer.
So someone did have a question. They asked, would it be possible to share a chart with the age of consent laws? For sexual consent, we do have, an article specifically on the sexual consent of teenagers where there's a handy little chart that says, not chart, sorry, a table with the age of the person consenting and how old the other person has to be for it to be valid. I also shared in the chat the link to our poster on age of consent to sexual activities. So that one you can view online, or if you want, you can order it for free. And we'll send you copies directly to your either home or to your institution, your school, for free. So if you want to order those posters for your classroom, please feel free to do so. And then someone just added, what is the age of consent for unnecessary care? So again, once you're 14, you can you still need your parents' approval as well to have that unnecessary care. So again, cosmetic surgery, etc. But otherwise, you do have to be 18. So in the case of consenting to healthcare, the two ages or two numbers you want to keep in mind are 14 and 18. So before 14, parental consent always required. Once someone's 14, then they can consent on their own to necessary care. And then it's once they're 18 that it's pretty much all care. It's as long as they're, able to understand what they're consenting to, they're, awake and they can share that consent, then it is valid consent to all types of care.
Someone is asking, will you guys be talking about the subject of pornography today? In the older elementary grades, we sometimes hear of this issue as an issue, students sending each other inappropriate content between each other. So we will be talking about inappropriate content that's being sent between students. I don't think we talk about pornography specifically,
When
but
it comes to
yeah.
child pornography, we're not going to cover it in this morning session. However, if you are signed up to the afternoon session on, navigating digital life, that is where we'll be talking more specifically about child pornography, sending videos, images, how that's treated when it's a minor, that's sending it to, say, their boyfriend, girlfriend versus sending it to someone else, etc. So if you are curious about that specific topic, I do recommend you go to the afternoon session as well, where we'll be covering that subject more in detail.
Great. I don't think there are any questions unless someone wanted to ask one last question before we move on to our next topic. No?
Great. So I think we can move on. So now we're at our next section here, risky or illegal situations. In this section, just a little note, we'll be using the word victim because it is the term used in the criminal code. But other terms like, the child or the teen involved or even survivor can be used depending on, your preference and what you feel is most appropriate for your group. So, if you know that there are some situations that have happened in a student's either personal home life or at school, then you can decide what term to use. Just because it is important to be mindful of the words we use when talking about sexual violence, since they can influence how the people concerned feel, how comfortable they'll be, taking the next steps, etc. So let's start with a little vocabulary lesson here. So there are all kinds of situations that can come up in young people's romantic and sexual lives that could be not allowed, illegal, or even criminal. So not allowed, illegal, criminal, these are not quite the same thing. So now we're going to look at each of these one by one just to kind of clarify what they mean. So behavior that is not allowed could be not allowed because of rules set by parents or by a school's code of conduct, for example. So these behaviors are not necessarily illegal under the law. Schools have their own internal policies, which can actually be stricter than the law. So, for example, because children are still learning about civility or just being polite. So, there could be rules about just being polite, being on time, etc., that wouldn't be in the law. So, it wouldn't be illegal and it wouldn't be criminal either. Next, illegal. So this means that there is a specific law or a regulation that prohibits or regulates a certain behavior. So it is actually in a law, in regulations set by the government. And then criminal is even more serious. So this is behavior that is necessarily illegal, not allowed, but it's specifically defined in the Criminal Code of Canada. So it is a crime and can lead to serious penalties. So, for example, sexual offenses, sexual assault are defined in the Canadian Criminal Code and therefore are criminal. We briefly mentioned this earlier, but something important to understand is that people can start being accused of crimes starting at age 12, which is quite young. So it's important for you and for your students to understand the different rules that surround them and the fact that some broken rules can be more serious than others. So again, starting age 12, someone can be accused of a crime, but the legal process is different for teens than for adults. But again, teens 12 and up can be found responsible for crimes. So they could go to court, they could, get a penalty if they commit crimes. We'll come back to this later, but if you ever think that, a student of yours is in a situation where there is, a criminal sexual act that happened, or if someone needs support, there is a free and confidential resource called the Sexual Violence Helpline. And again, we'll show that in the resources page as well, but the Sexual Violence Helpline is available for both young people and the adults who support them. They can give you, help, more personalized information, direct you on what, the next steps could be. So again, we'll share their contact details at the end of our presentation. So now we're going to ask you a series of questions to explore different types of risky or illegal situations. So here's our first question. Is this not allowed, illegal, criminal, or none of these? So a student repeatedly sends messages to their ex, even though the ex has asked them to stop, and they also wait for their ex outside of their classes. Someone answered illegal, so not necessarily criminal, but illegal. Someone else wrote criminal. Do we have other guesses? Illegal, illegal, not allowed or illegal, I can't decide. We seem pretty split here, but it seems like a lot of people are saying illegal. Someone wrote criminal harassment. Definitely an interesting notion there. Not allowed, not allowed. Depends on age gap. Illegal. So the answer here is actually that it's definitely inappropriate in any situation, but it's not actually necessarily not allowed, illegal, or criminal. So the technical answer is none of the above. Depending on the situation, it could be criminal harassment, as someone wrote. But with the information we have on the screen, or just this information, all we can say is that it's a risky situation. So it's not necessarily not allowed, illegal, or criminal with the information we have on hand. But Gail will explain when this risky behavior can become criminal behavior. So both illegal and not allowed as well if it's criminal. So there we go.
Yes, thank you. So yes, indeed, there are certain behaviors that can become so insistent, so serious that a person starts to fear for their safety. We could talk about harassment, so repeated text messages, repeated phone calls, having the impression of being watched or followed, so stalking. And all these behaviors could be criminal harassment, but they're not necessarily criminal harassment. To be criminal harassment, the behavior has to be directed at someone, and it also has to cause them fear for their physical, psychological, or emotional safety, or for the safety of someone they know. So, for example, it can be psychological, sexual, or discriminatory harassment, and still, sorry, it can be psychological, sexual, or discriminatory harassment and still be not illegal because the person does not fear for their safety. So it's really important that the behavior causes the person to fear for their safety.
Just a
Um,
note there.
uh,
So psychological, sexual, discriminatory harassment is not necessarily criminal, but it is illegal because of other laws.
Thank you for the
Yes.
specification. Another example would be repeated texting, even if the person said, please stop texting me. Again, this might not be criminal harassment if the person is not fearing for their safety. Uh, Definitely that's inappropriate, but it's not necessarily criminal. And another condition, in addition to the person being scared for their own safety, is that the person doing the behavior know or is reckless about the fact that the other person feels harassed. Um, does harassment happen in school? It can. So some schools have policies that cover violence, bullying, harassment, and in a lot of those policies, they do address harassment, even if it's not criminal. So as Julianne mentioned before, policies can cover broader things than what the law does cover. Thank you. So now we're going to look at two illegal and criminal situations. The first one is indecent acts. So what's an indecent act? That's a gesture that's considered offensive or insulting according to societal standards. So even if there's no physical contact, it could still be considered an indecent act. So someone that's found guilty of that could get a sentence of 2 years in prison, and those acts often occur in public, but it doesn't have to be something that's done in public. It can be also carried out in a private space and still be criminal. So what's really important is whether it was intentionally visible and if it was meant to shock or disturb others. So for example, someone that's engaging in a sexual act in front of an open camera or voluntarily just leaves the door open while they're doing that sexual act so everyone can see, that can be considered an indecent act, even if technically it was done in a private space. The second situation is exhibitionism. So, exhibitionism is a separate criminal offense and it has its own specific criteria. It applies to someone who exposes their genitals to a person that's under 16 years old for a sexual purpose. So, it also doesn't matter whether it happens in public or in private. What really matters here is the age of the person who witnesses the act and the sexual intent behind it. So here, that would have to be someone under 16 years old. Although we often confuse both these terms, so exhibitionism and indecent act, they're really different and not the same under the law. So quick question again for everyone. Is this not allowed? Is this illegal or is this criminal? If a student touches a classmate's butt from behind in the hallway in front of their friends and just say, oh, that was just a joke. So you can answer again in the chat or raise your hand. Not allowed. Not allowed. Is there intent? That's a good question to ask ourselves. Is there context missing? So the answer actually is that this is a criminal. So there is sexual contact, there is no consent. So it could be considered a crime depending on the circumstances. So the person who asked for more context would be right? This is a good reflex to have. So even if it is just a joke, it could still be considered sexual assault if you touch someone's butt.
Absolutely. So that's where we're moving on to now. So something more serious, sexual assault. So under criminal law, sexual assault can lead to very severe penalties, so up to 10 years in prison. And in the most serious of cases, for example, if there is a use or threat of use of a weapon, or if the person's life was put in danger because of the act, then the maximum penalty is actually life imprisonment. So in the previous, question that we just saw, touching a student's butt as a joke, technically it can be sexual assault. Now, in practice, will this be brought to court and will they be punished with these types of consequences is another question that we can't answer today, but we're really talking about what the law itself states. Sexual assaults can again happen between two people who are in a relationship because being in a relationship doesn't necessarily mean that consent is assumed. For there to be sexual assault, the law really requires three elements. So there must be physical contact of a sexual nature and without the other person's consent. So let's break these down one by one. The first element here is physical contact. So this is a really broad concept. It doesn't necessarily mean an explicit sexual act like penetration or oral sex. So a kiss or a touch can qualify as physical contact under the rules regarding sexual assault. And in some exceptional rare cases, a person can actually be found guilty of sexual assault even without physical contact. Again, this is really rare, but an example that was found by the court is that if someone masturbates near another person and forces them to watch, creating a threatening situation where the victim fears an imminent physical sexual assault, then that person could be accused of sexual assault even without that actual physical contact happening. Next, the sexual nature of the contact. So the act must have a sexual connotation. So some gestures may or may not be sexual depending on the context. For example, an exam done by a gynecologist or a massage is not sexual assault because the intention behind the act is not sexual. So it's really the context and the intent behind the act that matter here. And the third element of sexual assault is the lack of consent. So for there to be sexual assault, the act must be intentional and carried out without the other person's consent. So when assessing consent, what matters here is really the victim's state of mind at the time of the act. Did they want to participate in the act? Did they feel free to say yes or no? Were they afraid, under pressure, feeling trapped? So it's really the victim's state of mind here. So, what should you do if sexual assault or another crime happens, or if you think something might have happened to a student? Before we get to the answer, I just want to quickly remind everyone that the goal here again is to give you enough information to help you understand the situation and guide your students appropriately. So, it's neither your role nor mine to determine whether a sexual assault or any other crime has actually happened. That's really up to the courts to determine. But what you can do is listen to the student and ensure their immediate safety. So if necessary, contact the police, call 911, and the police are really the ones who will investigate the situation, send the information to the criminal and penal prosecuting attorney. The prosecutor is a government lawyer, and they're really the ones who will decide if someone should be charged with a crime. And to do so, generally, they need enough evidence to be able to go forward with an accusation. So that's where the police comes in. After their investigation, they'll send all they have to the criminal and penal prosecuting attorney. After that, if there are accusations, there will be a fair and impartial trial before someone is found guilty of a crime and then given a sentence. Something else you can do if there's no immediate safety needs there is you can inform the school administration, make a report directly to the National Student Ombudsman or the Youth Protection Services. So Youth Protection Services and the National Student Ombudsman can really then decide what to do. Do we move forward with a case? Do we file a complaint? Do we have an intervention with the other student? Or the other person involved in the incident. So they'll really determine what's in the best interest of that student, of that other person. Again, we'll present resources at the end of the workshop that can help you with all of these steps. how do you make a complaint to the National Student Ombudsman? What are the steps, etc. Those are things that the resources will present can help you with. So before we go on our break, let's do one last true or false question. So true or false, a sexual assault necessarily involves a sexual act with penetration. We've got quick answers this time. A lot of people saying the same thing. I think it's pretty unanimous. The answer is false. Good job. So on that note, let's take a short break. So it's going to be a 5-minute break. So let's meet up again at 10:35. So welcome back, everyone. Let's continue talking about risky or illegal situations. So here's a new question for you. Is this not allowed, illegal, criminal, or none of these? So here the situation. A stranger sends you a video of their private parts. A stranger sends you nudes or videos of their private parts. So is unsolicited nudes, videos, risky, um, not allowed, illegal, or criminal? We've got some people writing illegal, illegal, no consent, so illegal, criminal, illegal, criminal. It seems like most people are going more on the illegal side than the criminal side. Yeah, so the answer is that, it is. Oh, sorry. I thought there was a slide for the answer there. So there's no specific crime actually in Canada that prohibits this in all cases. But depending on the situation, on the circumstances, like the age of the person receiving the video, it could be criminal. But in other situations, it could simply be inappropriate without being illegal or criminal. So some places around the world have made sending unsolicited intimate images a specific crime to address this behavior directly, but this isn't the case in Canada at the moment. So we don't have a specific crime for sending unsolicited intimate images, videos, etc. But as I mentioned, depending on the age of the person receiving the video, it could be a crime. And that's because there are many sexual crimes involving minors where the age of the child or teen could determine whether a crime has been committed or not, and if so, which crime applies. So, for example, if the rules regarding sexual consent and age gaps aren't respected, different crimes can happen even without violence being involved. So you have 4 examples on the slide here, so let's look at them one by one. The first one is sexual exploitation. So in this case, the sexual partner of a teen 16 or older can be accused of sexual exploitation if the relationship makes the teen dependent on the partner or if the partner exploits the teen. So a partner who is in a position of authority or trust over a teen can also be accused of sexual exploitation. Someone found guilty of sexual exploitation could be sentenced to up to 14 years in prison. So very serious consequences here. The next one is sexual touching. So a person can be charged with sexual touching if they don't respect the legal age gap requirements, or if they are in a position of authority and touch any part of a child under 16 for a sexual purpose. So sexually touching a child using an object is the same thing. It would be the same crime. So it would be sexual touching, even if you're not, touching the child directly with your hands. If you're using an object, it could still be sexual touching. And here too, it can lead to up to 14 years in prison. Next, luring. So the law doesn't only apply to physical contact. So asking or encouraging a minor to engage in sexual acts can also be a crime, even if nothing happens in person. So this is known as luring or incitement to sexual contact. So for example, here, chatting online with a 15-year-old and inviting them to touch their own private parts, or asking a 17-year-old for nudes via text message could be considered luring. And the fourth one, making sexually explicit materials available to a child. So it is also a crime to make, nudes, sexually explicit materials accessible to a minor. So again, here we're talking about images, videos, or even sexually explicit messages. So if you're sexting a minor, not good. It could be a crime. So, well, it is a crime. So in other words, the law intervenes really early to prevent young people from being exposed to, manipulated, or sexually exploited even before any physical contact occurs. So in the scenario that we saw earlier, the true or false question, if the person is under 18 years old, then it would be a crime. So the crime of making sexually explicit materials available to a child. Now, we do have a final crime on the slide, which is the non-consensual sharing of intimate images. So there are about 300 charges per year against young people related to child pornography, often linked to the non-consensual sharing of intimate images. Key factors include, easy access to technology nowadays and social media. So there's rapid sharing of these images online, interconnected platforms where you can just share things across platforms as well. So a very important topic here. So most young people have phones, which again makes instant creation of these types of pictures, videos really easy and also easy to share. And they could do so because, sexual excitement, or they're curious about exploring their sexuality, or they have a desire to please or attract someone by sending them an image. And sometimes even, revenge porn is a thing that's more and more common amongst young people as well. So these are all types of reasons that could lead someone to sharing these types of images with others, or sharing things that they've received from people around them with others. So what exactly is allowed and not allowed? So first, before we move into that, what exactly is an intimate image? An intimate image can be a photo, a video, an image with sexual content showing primarily genitals, breasts, butts, or explicit sexual activity. So this image can be taken by the person themselves, or it can be taken by someone else with the person's consent. Or it could be taken by someone without their knowledge or their consent. For example, a picture taken in a locker room or a bathroom. So all of these, whether the picture itself was taken with consent or without consent, if they're shared without consent, so here we're really talking about the crime of non-consensual sharing of intimate images, that's really where the consequences can be serious. So a crime can occur when a person shares, posts, sends, or shows an intimate image without the consent of the person involved. And it can lead to up to 5 years in prison. So this is a crime regardless of the method of sharing, whether it's by private message, text, social media, email, even printing an image and distributing it to people or showing it to people in person can count. And it also doesn't matter how many people actually see that image. So even just sharing it with one person is enough for the person to potentially have committed a crime here. So again, showing an intimate image to another student, on a phone without consent can be considered a crime. And if you're curious about, the rules regarding child pornography, in the afternoon session, we'll be covering that more in detail. So let's move on here. So as we just saw, there are many sexual crimes involving minors. So true or false, I thought they were 18 is a valid excuse in these types of situations. We've got people saying false, no, false, false. I think this is pretty clear too, pretty unanimous. The right answer is false. So there are some crimes that only apply when a person is a minor, and saying, I thought they were an adult or that they were 18 is not a valid excuse in most cases. There is an exception, so it is valid, and it's only valid if the person actually took all the reasonable steps in the situation to verify the other person's age. So this will really be examined on a case-by-case basis. What were the red flags, for example? And then also reasonable steps that they could take would be, for example, asking the person directly, or if there's still many red flags, requesting to see an ID, etc. So there are different steps that you could take to make sure someone is an adult, if ever there are those red flags. So courts really look at the full circumstances to see if there should have been steps taken. Did you take all the reasonable steps? And then if not, well, then that excuse of I thought they were 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 , 18 ,
So now we have arrived at our final topic for this section, which is domestic and intimate partner violence. Those two terms can be used to talk about this sort of violence. And this sort of violence doesn't only affect adults, so it can also happen in relationships between young people. And because school is often where young people spend most of their time, it's often where concerning behaviors can be observed more early in their relationship. So it's really important to understand this phenomenon just so we can intervene earlier and support the students involved, and when necessary, also report the situation to the appropriate resources. So we're going to start with the violence part. In a school context, what's considered violence is the use of force against someone. So that can be verbal or written, it can be physical, psychological, sexual, and more. And it also has to be directed either at the person or at their property. Now, when it comes to domestic violence, that can be physical, psychological, sexual also, but it can also be economic or judicial and others. It's often based on control strategies, and it can follow a cycle where violent episodes alternate with periods of calm. So uh, it can, it can be harder to spot because of this alternation. And although it's not a crime in itself, many of the behaviors involved in domestic violence are criminal. So, for example, assault, threats, sexual assault, and things like that. Um, how, However, since 2019, the notion of intimate partner violence has been added to several sections of the criminal code, which affects decisions about pretrial detention and protection orders. And it also can affect the penalty that someone will have once they're found guilty of a crime, so the sentence. So just a quick recap about risky or illegal situations. Some situations can be seen as harmless, but actually be criminal. So as we saw, touching someone's butt just as a joke, that could be considered sexual assault. Some actions are criminal because they involve minors, so they might not be criminal otherwise, but because minors are now involved, now they're considered criminal. So, for example, luring and sexual exploitation. And again, your role as educators and sexologists and people who work with those students of all ages is really to inform, to prevent, and to intervene whenever you are made aware of such situations.
We do have a question period here. I invite people to write the questions in the chat and we'll actually answer them at the next question period. I'm just looking at the time here. So I guess for now we'll move on and we'll answer all the questions at the next question period. So we are at our last section before the conclusion. We're going to talk about responsibilities of school staff. And here again, we'll start with a true or false question. So, true or false? Anyone who has reasonable grounds to believe that a child is being sexually or physically abused must report the situation to Child Protection Services, which is to say the Director of Youth Protection. So, does everyone have this obligation or is it limited to specific people? I think we have a lot of trues so far. Yes, legal obligation. Anyone? True, true, true. True. I think we're pretty unanimous here. And the answer is true. So when it comes to sexual or physical abuse, the obligation applies to everyone, not only to adults who work with young people like teachers. You don't have to have proof to make a report either. So as long as you have reasonable grounds to believe that a child is being sexually or physically abused, there is an obligation to report it to the Director of Youth Protection. So, under the Youth Protection Act, teachers, daycare educators, healthcare professionals, and other adults who work closely with children do have a duty to report all situations that put a child's safety or development in danger. So, including psychological abuse or neglect. And they have to report the situation to the Director of Youth Protection. As we just saw, this duty to report to the Director of Youth Protection extends to everyone when there are reasons to suspect physical or sexual abuse of a child. And here, the definition of sexual abuse under the Youth Protection Act is different from that under the Criminal Code. So the criteria here is whether the child's security and development is in danger. So it doesn't necessarily have to be a crime for it to be sexual abuse that needs to be reported. A report to the Director of Youth Protection could lead to criminal accusations if ever there actually was a crime, but this really depends on the situation. It won't happen every single time. The law also states that an adult must provide the necessary assistance to a child who wishes to report their situation or that of their brothers and sisters or of any other child. So this is a really complicated sentence there, but in short, if a student comes to you for help for themselves or for someone around them, then you do have an obligation to help them with their, reporting a situation, with getting help. So here's our next true or false question. True or false, if young people are participating in sexual activities at age 11 or are not respecting the age gap rules, I must inform the parents. So here, as we saw before, age 12, sexual consent is not valid. So here, if someone is having sexual activities age 11 or are not respecting the age gap rules, do you have to inform the parents? A lot of people say true, I must inform the parents. I think, is everyone answering true? Yes, yes, yes. True. Could administration do it? Good question. So surprisingly, the answer here is actually false. So you don't have to inform the parents. You don't have a legal obligation to do so. And actually, this is not necessarily always what is safest for the students. So the parents might not necessarily be the best people to deal with the issue. Someone answered potential child on child sexual abuse called the DYP. Yeah, so those are other things that you could do. So, but if we come back to this here, the school is actually also not required to call the police, for example. The key reflex here is to take the situation seriously and assess it. So you do want to consult internal resources, going to the school administration, for example, following reporting procedures for these types of situations. It might be in the plan on anti-bullying, anti-violence, or a separate plan procedure. You also might want to make a report to Youth Protection Services or the National Student Ombudsman if necessary, if you believe the child's safety or development is in danger because of what's happening. So definitely, this is something that you could do. Call the DYP was a good answer here. Parents could then be informed by the Director of Youth Protection or the other services involved, depending on the situation. And again, Youth Protection Services, the National Student Ombudsman, and other services must act in the best interest of the child. So they're really the ones that will determine whether, involving the parents, involving the police, or involving other services is necessary or not.
So now we'll move on onto the topic of bullying. For Quebec schools, the law defines bullying when it includes these elements. So repeated actions or words, behavior that excludes or hurts the victim and makes the victim feel powerless, as well as when there's a power imbalance between the person who bullies and the victim. So as soon as those elements are present, we're going to consider that there's bullying, even when the person who bullies did not have the intention to cause harm. So the intention is not something that's taken into consideration. It will also be considered bullying, even if the person themselves that's being bullied is not present. So, for example, if someone spreads a rumor across the school, that could be considered bullying, and then the victim might find out about it later. Bullying can also happen online, and in that situation, we would call it cyberbullying. When there's bullying, schools have to act and stop bullying, and they actually are required by the law to have a plan that includes steps that they will take to prevent and to stop bullying and violence towards a student, but also towards a teacher or any other school staff member. And this plan has to include steps to prevent bullying, a procedure for reporting cases of bullying, measures to make sure complaints remain confidential, Also, the action that will be taken against bullies when bullying is reported by a student, a teacher, a friend, or anyone else. And also ways to support victims or witnesses of those situations. This plan has to be sent to the parents, and the students also have to be given a training on bullying and also on what action will be taken against students who bully others. So the school's employees also have to participate in this act of protecting students against from violence and bullying. And for example, the school principals have to receive any and all complaints of bullying and violence and then let the parents know about those complaints. And if we're in a private school, then the member of the board of governments have to quickly tell the parents when such report is made. Uh, the actions that have to be taken against the students who bully others will really depend on how serious the behavior was. So it can go from just a detention to a letter of apology to a suspension and even being expelled from the school. And now we look at another true or false. Gender identity and gender expression are not protected under Quebec law. Is that true? Is that false? What do you guys think? You can write in the chat or false, false. Yes, so the answer is indeed false. Gender identity and gender expression are protected under several laws in Quebec, such as the Charter of Human Rights and Freedoms, the Education Act, and the Act respecting private education. So, as I mentioned earlier, schools do have a duty to create a safe and inclusive environment for all students. So, they have to when they mention bullying in their policies, they have to also consider bullying based on sexual orientation or gender identity. So when we talk about discrimination based on such factors, we talk about something that prevents a person from enjoying the same rights or accessing the same services as others because of those characteristics. And harassment that's based on discrimination would also harm that person's dignity or their psychology and well-being. So if a student experiences such discrimination or discriminatory harassment, they have to be able to go to the school staff for help, and the school has to then apply the plan, the anti-violence, anti-bullying policies that we've talked about. The students could also choose to file a complaint with Quebec's Human Rights and Youth Rights Commission, the Commission des droits de la personne et des droits de la jeunesse. And that commission role is to protect against discrimination based on the grounds that we mentioned. So sexual orientation, gender identity, gender expression. So yes, that's a thing that students can do. And here, just a recap of all the responsibilities of school staff. So they have to act quickly as soon as they hear about such situation of violence or bullying happening. They have to inform the school administration and then use all internal resources to try to solve the issue. They also can report the situation to the DYP, and in some cases, doing that report is mandatory. And they can also report the situation to the National Student Ombudsman. Not sure how that's pronounced. And then those institutions will assess the situation and see what can be done.
So let's just quickly go through our conclusion before we do our final question period. I just want to show this slide in particular. So the resources that you see on the slide, you can take a screen grab, a screen capture if you want, just to have everything on hand. But again, this presentation will be put online, so you'll be able to access all of this information and these resources at a later time if you so wish. A couple important ones that I'm going to explain maybe a little bit more in detail. The Sexual Violence Helpline is a 24/7 telephone helpline intended for people who have experienced sexual violence and their loved ones as well as frontline workers. So there's a specially trained team that receives the calls, provides information, and also directs people to the nearest resources, offering one-on-one assistance and protection as well if that's what your situation requires. So they can really direct you to what you need to do, who you need to contact, and give you more help in how to support someone or what to do if you yourself go through a sexual violence incident. The next one I want to talk about is Interling. So Interling is a nonprofit that offers help and information to people concerned with sexual diversity and gender plurality. So again, available 24/7 by phone, text, or online chatting. So if ever you have students who are questioning or who have questions regarding that, it's a great place to send them for information. The next two as well, Let's Talk Law. So Let's Talk Law is a phone service by appointment offered by volunteer lawyers from the Young Bar of Montreal to anyone, to young people aged 12 to 21 across Quebec. So if they have a question, they can talk to a lawyer for free. The lawyer will simply call them and answer their questions, give them information, help them understand their rights and their recourses. And then the last one, Tel Jeune, which is a free and confidential frontline support service for teens aged 12 to 17 and their parents in Quebec. So services are available again over the phone, by text, online chatting. So you can get help with, violence, relationships, sexuality, other challenges as well. So a great resource to have on hand. So this is now our time for any last questions you may have. We did again answer some directly in the chat while the other person was presenting. So if ever you ask a question in the chat, there's likely a answer already in the chat as well. But if you have any additional questions, now's the time to ask them either in the chat or by raising your virtual hand so we can ask you to unmute. While people are typing out their questions, I'm just gonna put up this slide here. We do have a quick little evaluation form for you to fill out if ever you have, 2 minutes. It does greatly help us adapt our content to make sure that we answer real needs that educators have. I also just now put the link in the chat if ever you prefer accessing the form by a link rather than with a QR code. So really quick to answer what you appreciated, what you learned, what you would have liked to see. So great place to go. If there are no other questions, I think we'll let everyone go because we are 2 minutes late. So thank you very much for your participation today, your patience. I know that it's a lot of information. I hope it was useful, and we hope to see you at our afternoon presentation. It won't be us necessarily, it will be our colleagues, Reb and Sophia, but it'll be very interesting information as well.